Does a will avoid probate? Short answer, no it does not. I'm RJ Knapp, attorney and founder of Knapp Law, where we help families build a better legacy. And I often shock people when I share with them that a will actually cannot avoid probate. According to section 256.001 of the Texas Estates Code, a will is not effective to prove title to or the right to possession of any property disposed of by the will until the will is admitted to probate. That means that if you pass away while living in Texas, the only way a will can legally determine who gets your stuff is by taking your will to a probate court. A judge will have to look over the will and decide whether or not it's valid. Hopefully it says the right things, and you might even need to have a witness who signed the will show up and testify. If the judge admits the will is valid, then they'll appoint someone to be the executor of that will. And it'll be that person's job to gather all the stuff you owned or owed at the time of your death, make sure your debts are paid off, and then distribute the remaining property according to the terms of your will. Unfortunately, there are some things about probate that some may not expect. And again, a will doesn't avoid any of this stuff. First, in most situations, you will have to hire an attorney to probate your will. It would constitute unauthorized practice of law for an executor to represent the interests of others by administrating someone else's estate without the assistance of an attorney. Second, probate is a public proceeding. The will and an inventory of all the stuff you owned at your death are publicly filed with the probate court. This means that anyone who wants to can find out who is getting what from your estate. Third, probate can take a while. It's not uncommon for probate to last 6 months to over a year before your family is able to actually receive the stuff your will says they should be getting. That can be devastating if your family is hurting financially and they really need to access those funds quickly. You might be thinking, well, I don't like any of that, so what's the point of having a will? Well, if you don't have a will, then the Texas Estates Code has determined who gets what, and you'll still have to go to court to get it. Now, there is a simplified procedure available called a small estate affidavit. If you don't have a will and you only own certain types of property in certain amounts. But the vast majority of families that I've counseled over the years don't fit in that bucket. And their families had to do not only a full-blown probate administration, but because they didn't have a will, they also had to do an heirship determination beforehand, to hire a second attorney to investigate who the actual heirs are, telling the judge what you likely already know. And all of that costs extra time and money. Also, if you want your stuff to go to people in any other manner than what the Texas Estates Code has chosen for you, and if you want the probate process to run as smoothly as it can, then you should have a will that is set up properly by an experienced, licensed estate planning attorney. But if you want to avoid the time, cost, publicity, and potential for conflict that probate brings with or without a will, then there are other estate planning options to do what you wanted to do in the first place, avoid probate. If you want to learn more about those options and how they can help you and your family avoid court and conflict, then visit our website at knapp.law or just give us a phone call. We'd love to talk with you about it. Thanks for watching this week's Q&A, and let us know in the comments below if there are any questions you want for us to answer in the future. Bye, y'all.